removed the night before publication for quote-unquote fact-checking. Those allegations are false, and the New York Times either knew they were false or acted with reckless disregard as to their falsity.
This just in, Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
Baldoni's attorney just revealed a shocking twist involving Blake Lively and her supporters in the New York Times, flipping this legal battle upside down. It appears that fame and fortune don't always shield you from scrutiny, especially when you've got a legal mastermind like Brian Fredman on your team. With the latest revelations he disclosed, it's clear who's really winning this fight.
Private text messages and other documents that we've obtained reveal what really happened.
Honestly, the New York Times' deceptive coverage in the ongoing lawsuit involving Justin Baldoni and Blake Lively is central to this explosive case. The media giant took a firm stance against Baldoni, portraying him as the villain responsible for a smear campaign to ruin Lively's reputation. This portrayal immediately cast Baldoni in a negative light, leaving little room for nuance or the possibility that things might not be as straightforward as the Times made them seem. But that wasn't all. The New York Times didn't just report the allegations, they actively endorsed Lively's claims, presenting them as if they had been verified beyond doubt.
A journalist or media outlet by suing them for defamation or libel.
In their articles and accompanying videos, the Times depicted a scenario where Baldoni and his colleagues at Wayfair were the perpetrators of this grand conspiracy against Lively. This portrayal not only misrepresented the facts, but also crossed the line from neutral reporting into something much more sinister and defamatory. It wasn't until the dust began to settle and the lawsuit took shape that the New York Times realized the gravity of its mistakes. They knew that if Baldoni didn't step up, his lawyer Brian Fredman certainly would. This was the turning point for the paper.
Wrongly casting them as villains and making them scapegoats for Lively's well-publicized media missteps.
They acknowledged that without the intervention of Baldoni's legal team, the situation would have slipped under the radar, with public perception easily swayed by their misleading narrative. The New York Times' realization that they had overstepped led them to start distancing themselves from their own reporting. But at that point, it was too late. The damage was done, and the paper's credibility had already been questioned. Fredman wasted no time in highlighting these errors. He emphasized that the New York Times didn't just act recklessly. It actively participated in defaming Baldoni's character by endorsing Lively's claims. The Times crossed a line. They were no longer reporting allegations, but presenting them as facts. Fredman's argument was clear. The New York Times acted with malicious intent by knowingly presenting false information in the most damaging light possible.
The New York Times published a story titled, "We Can Bury Anyone," inside a Hollywood smear machine.
This wasn't just careless journalism, it was calculated manipulation. By actively backing Lively's version of events, the Times gave the impression that their investigation had verified the truth of her claims. In reality, much of what was presented lacked the necessary journalistic rigor to stand up in court. This went far beyond reporting. It was an attempt to shape the narrative to fit a specific agenda.
That the Wayfair parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film.
Now let's move to the legal battle unfolding, with Brian Fredman leading the charge against the New York Times' attempt to dismiss the defamation lawsuit. The Times filed a motion to dismiss, hoping to have the case thrown out before it could gain any real momentum. But Fredman, not one to back down, countered with a strong legal argument. His focus was on the fact that the New York Times had forfeited its fair report privilege.
The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfair parties and falsely accused them of having waged a smear campaign.
This privilege is a critical shield for media outlets, protecting them when they are simply reporting on matters of public concern. However, as Fredman points out, the Times didn't just report on Lively's claims. They presented them as facts. They took the claims and acted as though they had been substantiated through their own investigation. Fredman's central argument is that the fair report privilege doesn't apply when the media outlet moves beyond simple reporting and starts acting as an advocate for the claims being made. By framing Lively's accusations as verifiable truths, the Times removed any protection they might have had under this privilege. This isn't just a small oversight. It's a serious breach of journalistic ethics.
It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
Fredman's team is pushing hard to ensure that the Times is held accountable for their actions, arguing that when a media outlet has the power to shape public perception, they also have the responsibility to get things right, especially when lives and careers are at stake. The Wayfair parties, including Baldoni, have pushed for California law to be applied instead of New York law, arguing that the defamation and harm they suffered occurred in California. This move is a strategic maneuver aimed at shifting the legal landscape in favor of the Wayfair parties, particularly Baldoni, who calls California home.
Baldoni saying, hey, it just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond. We scrambled, and you still published it before we could even get our response to you.
California law, known for being more protective of individuals' rights in defamation and false light cases, presents a stark contrast to New York's legal framework. California law allows for broader protections against defamatory statements, especially in the context of false light claims, which can be particularly important for public figures like Baldoni. Under California law, a defendant can be found liable for placing someone in a false light if the publication of false or misleading statements creates a distorted image of that person. This legal provision could have significant ramifications for Baldoni's case, as it provides him with a more robust avenue for pursuing damages and holding the New York Times accountable for its actions.
The New York Times prepared its salacious article well before TUI contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times' months of plotting with the Lively parties, the Wayfair parties got hours to respond.
California's defamation laws also differ from New York's in their treatment of damages. In California, a plaintiff can recover emotional distress damages more easily in defamation cases. These types of damages, which are harder to win under New York law, could provide a substantial financial remedy for the harm done to Baldoni's reputation. In California, a plaintiff can pursue damages for both the reputational harm and emotional distress caused by false and defamatory statements. This means that Baldoni could potentially recover more substantial compensation if the case is tried under California law.
The New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfair parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties.
The application of California law could also make a significant difference in the legal strategies of the parties involved. The Wayfair parties have argued that the defamatory statements and false light accusations published by the New York Times caused significant damage to their reputations, particularly in California where they reside and work. By applying California law, the Wayfair parties could strengthen their claims, making it easier to prove harm and collect damages. Additionally, California's legal system is known for its tendency to favor individuals over large corporations, which could benefit Baldoni in his fight against the powerful media institution that is the New York Times.
A jury will determine the truth based on the evidence, but the Wayfair parties' allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfair parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California.
However, the New York Times, being based in New York, has strongly opposed the application of California law. The newspaper's legal team has argued that New York law should apply, claiming that the case should be governed by the laws of the jurisdiction, where the New York Times is headquartered. This presents a legal conflict between the two states, each with its own set of rules and standards for defamation cases. The Times' argument is grounded in the idea that it is a New York-based publication, and that the alleged defamation took place through its publication, regardless of where the individuals involved reside or work.
The New York-based New York Times insists it is entitled to New York law no matter where their harm was felt, but California law remedies harms suffered in California by California residents.
The outcome of this legal dispute over jurisdiction could have a major impact on the damages Baldoni and the Wayfair parties could potentially recover. If California law is applied, the stakes would be much higher for the New York Times as they could face a more significant financial penalty and potentially more severe reputational damage. In contrast, if New York law prevails, Baldoni and his team would face a much more difficult uphill battle, as the legal protections under New York law are not as favorable for individuals who claim to have been defamed.
Under either California or New York law, the Wayfair parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report privilege.
Moving on to the issue of actual malice, Fredman, Baldoni's attorney, has presented a strong case that the New York Times acted with malice in its reporting on the Baldoni-Lively legal drama. In defamation cases, the concept of actual malice plays a crucial role, especially when the plaintiff is a public figure like Baldoni. The actual malice standard requires the plaintiff to prove that the defendant published false information with knowledge of its falsity or with reckless disregard for the truth. Fredman's argument hinges on the idea that the New York Times knew the claims made in its article were false, or at least should have known they were false.
But they argue your defamatory statements affect my client specifically in California. And this modern world we live in with the internet really makes it that you're damaged no matter where the defamation takes place.
He contends that the newspaper had access to documents and communications that disproved Lively's allegations, yet it chose to ignore this evidence and publish a one-sided narrative that portrayed Baldoni as the villain. The article, as Fredman asserts, was not an objective piece of reporting, but rather a calculated attempt to further Lively's version of events while tarnishing Baldoni's reputation. By choosing to publish this false narrative, Fredman argues that the New York Times acted with actual malice.
The New York Times has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department complaint.
The Times' failure to properly vet the claims and its disregard for contradictory evidence supports the idea that it acted with actual malice. Fredman's team points out that the Times had access to private communications between Lively, Baldoni, and others involved in the case, which could have undermined Lively's claims. Despite this, the Times chose to publish the article and video that painted Baldoni in a negative light without adequately considering or addressing the evidence that contradicted Lively's allegations.
And actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability.
Black's Law Dictionary defines the phrase smear campaign as the deliberate telling and repetition of untrue or distorted stories about a person to make others lose respect for that person. In addition to the actual malice standard, Fredman highlights the reckless disregard for the truth that the New York Times exhibited in publishing the article. The Times didn't just fail to investigate the claims thoroughly, it actively manipulated the information it had. They were presented as statements of fact based on first-hand knowledge of the evidence. In that context, a reasonable viewer would have interpreted the New York Times' smear machine and smear campaign statements not as mere hyperbole, but instead as provable. Fredman's argument is that the newspaper didn't just make an honest mistake. It willfully ignored the truth in order to push a narrative that benefited Lively and Reynolds.
For maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair parties.
As a non-legal expert, I look at this and think he's making a valid point. We'll see what the judge has to say. The New York Times' statements imply that the Wayfair parties engaged in grossly immoral conduct to cover up even more grossly immoral conduct. One of the most striking aspects of Fredman's argument is the claim that the New York Times manipulated the narrative by selectively using text messages and other evidence to create a misleading story. The article presented a one-sided view of the situation, relying heavily on Lively's allegations and framing them as verified facts. Such statements resulted in the destruction of their reputations and careers. The statements by the New York Times cannot be and were not construed as mere statements of opinion or hyperbole. Fredman argues that the Times took these documents and texts out of context, splicing them together in a way that created a false impression of events. This is not just reckless reporting, it's a deliberate attempt to mislead the public and sway public opinion against Baldoni.
It's probably better for them to double down on their beliefs that they did the right thing versus admit defeat.
Biased, one-sided story that ultimately harmed Baldoni's reputation. Lady C's insight into the situation sheds light on the broader issue of media manipulation in high-profile legal battles. It highlights how easily the press can be used as a weapon by those with the resources and influence to control the story. The consequences of such manipulation are profound, not just for the individuals directly involved, but for society as a whole. When the media is complicit in spreading false or misleading information, it undermines trust in journalism and leaves the public with a skewed understanding of events.